Good morning, folks. This is immigration attorney Ismail Shahtakhtinski and the principal attorney at I.S.Law Firm. In this video, I wanted to talk to you about prosecutorial discretion, how it works in practice, and an example of a case that I had yesterday. So I just came out of the bond hearing, which was held remotely, as most of the immigration court hearings are being held. But yesterday, we had an immigration court hearing on an asylum case, individual hearing on an asylum case, for a client of mine in Boston Immigration Court. And in an example of this case, I will describe how the prosecutorial discretion works in play. So the prosecutorial discretion is something that came out during the Obama administration, when the government, Immigration and Customs Enforcement, decided that they will not prosecute every case in immigration court, and they will prioritize those cases that are against those removal proceedings that are against the foreign immigrants who have criminal history. So those individuals who are in removal proceedings, who don't have a criminal background, not to overwhelm the immigration courts, the government is willing to dismiss those cases. But aside from the dismissal of the cases, in April 25 of 2022, the Immigration and Customs Enforcement began also expanding the discretion in terms of possibly granting asylum to those individuals who are eligible based on paper. So instead of having an immigration judge consider the case in immigration court, the government attorney would, before the hearing, review the papers. As long as the attorney for the respondent, for the applicant, prepares the application for prosecutorial discretion, they would review the package and they would decide if this individual deserves asylum, or maybe they can stipulate to part of the relief or one relief or another instead of going and fighting in court. It's almost like encouraging the settlement if we look into the civil type of case, or plea agreement if this is a criminal type of case. But it's a lot more flexible than I would say in a criminal case. So starting from April 25, they started implementing this, where the government attorney, the prosecutor in immigration court, goes through the file of the applicant, of the respondent in the removal proceedings before the hearing, and makes up his or her mind how they're going to move, whether they will file a request to dismiss the case or whether they will agree to the form of relief or not. So yesterday we had a case also remotely held from this room. This is my home office, and in the 21st century and during the pandemic, most of the hearings are being held remotely through WebEx online, which is a good thing, and it's very convenient for all the parties and cost effective as well, including for the court as well, because the interpreters also show up at the hearings remotely. They don't have to have crowded courtrooms and so on. But anyway, going back to the prosecutorial discretion. So what happened yesterday? So yesterday we had a strong asylum case, and this was an individual hearing in Boston Immigration Court with Judge O'Malley. And the first thing in the hearing the government attorney did, he offered, the prosecutor, so to say, in immigration court, offered to dismiss the case. Now, from the first sound of it, it sounds like a good idea. Yes, the case is dismissed against my client. If this was a criminal court, we would be happy. But that's not the case in the immigration courts. The dismissal of the case is not always a good idea. The issue here is that my client deserved asylum. He fled persecution. He had well-founded fear of persecution, so he deserved the protection, the asylum in the United States, which would give him eventually a right for permanent residency 1 year later, and then down the road for citizenship. But if the case is dismissed, then he would just be unlawfully present here without anything. It's just the government doesn't have, meaning that the government doesn't have enough resources to remove him, and they would just allow him to remain in the United States. So because he applied for the form of relief for asylum, and because he had a strong case, we objected to the dismissal of the case, and the court agreed. Well, the court usually agrees by default, as long as the respondent objects, as long as there is some kind of form of relief pending. In this case, it was asylum. So we had the full-blown hearing. I started direct examination of my client, the respondent. We had an expert on hold who would be also testifying as to the country conditions. If need be, we provided the expert's report. But throughout the hearing, the judge was listening carefully, observing the demeanor of my client as he was testifying. listening to the questions that I asked and the answers my client gave. And the judge was also at the same time reviewing the documents we submitted, including the expert report, the country conditions reports, and so on and so forth. And at one point, judge basically interrupted me when I went too deep into the country conditions, asking from the respondent. The judge said, we got it all on papers, you don't have to question. And I realized that, most likely the judge agrees already with the form of relief we are asking. Then the government attorney questioned the prosecutor again, so to say, in immigration court, asked questions from my client, and the judge said that she reached her decision. The asylum was granted. The hearing took place for, took about 1 hour, 1.5 hours or so, which is relatively short for individual hearing in asylum cases. I've had individual hearings that lasted 2 days. I've had individual hearings that lasted an entire day, but very rarely it takes such a short amount of time. So in this case, we got the grant of asylum. Now our client is going to get all his paperwork and through United States Citizenship and Immigration Services as a result of the order of the immigration judge, and then eventually we'll file for his permanent residence in the United States. So that was a good result. In another case about 2 weeks ago, a similar thing happened when the government attorney showed up, but instead of asking for dismissal, the government attorney actually asked the court for asylum. And in that case, it was strange. It was the respondent side, we were going to ask for dismissal because the respondent was also married with a United States citizen, and so happened that we filed the petition, and the petition was approved, and the respondent was about to become a permanent resident based on the marriage. And we didn't want to risk going through asylum case and getting possibly order of removal, although most likely the judge wouldn't order removal even if the asylum wasn't granted. But anyway, we didn't want to go forward with asylum case, so we decided that she's going to become a permanent resident anyway, so why go for asylum? Although asylum provides a lot more benefits, more protections than permanent residency alone. I'll explain it in one of the videos. But why it is so. We showed up for the hearing. Again, it was about a week or 2 weeks ago. And before I was able to open my mouth to say, Your Honor, she's married a U.S. citizen, the petition I-130 is approved, let's get this case dismissed, or the government, would they agree to get it dismissed? The government attorney came back and said, oh, I reviewed the file and we agreed to asylum. This is a strong case, we believe. Now, granted, not to brag too much, we made it a strong case before she was able to marry the U.S. citizen. We provided lots of information and proof and documents confirming that she deserves asylum. So the government attorney reviewed it and based on the papers agreed to asylum. Now, I didn't hide the fact that we were going to ask for dismissal. I told them, but I said we'll take the offer, we appreciate it. And the reason why we took the offer is because, again, asylum grants more protection. For example, if you are granted asylum, you get to have a travel document, a refugee travel document, which basically replaces your passport, your country's passport. You become basically the subject of United States. A permanent resident is not a subject of United States. A permanent resident doesn't have protections of the United States. A permanent resident is just someone, is a citizen, is a subject of another country who is allowed to permanently remain in the U.S. But asylee, somebody who's been granted a refugee status in the United States, they've been granted protection in the United States. The United States treats them as their own, as our own subject, and we give them travel document which replaces the passport of their country so that they can travel to another country and present themselves as refugees from the United States rather than citizens of their country, which could potentially subject them to the jurisdiction of their country and possible extradition and detention in their country. And we've had those types of situations, not with our clients, but somebody who actually contacted me when there was an individual who was detained in Europe based on the red notice, Interpol notice, and thankfully they did have the asylum protection, so we were able to get them out. But in any case, so this is how prosecutorial discretion works. It's best to apply to prosecutorial discretion every time before the hearing. Will ask your attorney to prepare the package to include the bona fides of your residency in the United States and information about you. But I wanted to share this case information about you, how prosecutorial discretion worked in practice, and an example of the case we just had yesterday, so how it played out in court. So I hope everybody has a wonderful day, and if any questions, please call us. And if you like this video, if you find it informative, or if you want to see more videos and information about this type of cases, please hit like and subscribe to our channel. Thank you very much. Bye-bye.